put up a $50 million bond secured by the property, not only GPS monitoring, not only will he surrender his passport, all that. They say they have brought the head of Sage Intelligence today, and they are proposing that Sage Intelligence personnel, all former law enforcement, will be monitoring Combs' home 24/7 to make sure he doesn't leave. The defense is also proposing a visitor log, and they would give that list to the court, so who would be coming to and from his house. And the defense also says that Combs will not have access to a cell phone or access to the internet if he's let out of jail. Is that sufficient, Natalie?
I say that that is creative. And I, again, applaud the defense for how hard they're working for their client. I think that what it does do practically is address some of the issues that the court may have about Combs contacting witnesses. However, you have to question, I don't know anything about this company. I'm not casting any aspersions on them, but I don't know what their reputation is within the federal courts for doing things of this nature, because that's not the norm. People will be on GPS monitors, or they'll be in custody, or they'll be released without conditions, but it's not usually some private security firm basically making the person on home detention and house arrest at home. That's a little different. And so I don't know what type of quality controls that they have, and that might be the issue for the court. Outside of quality control, they're doing the best they can to address the issue of contact with witnesses, obstruction, and manipulation of evidence.
I mean, essentially what they're saying is all of your concerns that you have, that he's going to reach out to people, that he's going to leave, we can alleviate that. He doesn't need to be in federal lockup. He'll essentially be in lockup in his house. And by the way, Neama, another update. And by the way, if anybody has questions on YouTube, submit them. We'll answer them here on air. The defense is also saying that he's responsible. He's not a flight risk. He came to New York in anticipation of the charges. He gave up his passport. They took the passports of 5 of his family members. We have a letter of intent to sell his airplane. Your thoughts?
I agree with Natalie. A, for creativity. I thought the defense has done a good job addressing the flight risk, but there is no rich person exception to our federal detention laws or celebrity exception. What they're trying to do is basically put him on home confinement. And that's possible, but that's something pretrial services has to do and has to monitor. So if I'm the judge, and obviously I'm not deciding cases based on what the public perception is, but I have to think to myself, what sort of criticism is this court going to receive if we grant this really extraordinary type of pretrial detention that no other criminal defendant would be afforded the opportunity to do so? I would treat Diddy just like any other criminal defendant, or put him in pretrial detention, have pretrial services monitor him, make sure he comes to court. The marshals will bring him just like everyone else, because he's just like any other defendant who's been charged with drug and sex trafficking.
So here's the thing. The judge hasn't made a decision yet. But based on the reporting that we're seeing from inside that courthouse, it seems the judge, in my opinion, is going to side with the prosecution once again. Why do I say that? According to this, the judge just asked the defense to get to the point and said, if Combs was aware of the charges in April, why was he contacting witnesses? Again, that seems to be the point that neither Judge Tarnowski from yesterday or Judge Carter today, and even though, and Neama, you said it so well before, this is a district court reviewing the magistrate court decision de novo, meaning anew, from the beginning, fresh. It seems that this judge is also being persuaded, Natalie, that he should not be let out, that the idea of contacting witnesses is what set this off.
And that's what's going to get, so for example, say he had not contacted witnesses and he had been released on some type of pretrial services or a very high bond amount, and then he turned around and did it while he was out on bond, started contacting witnesses, that would get his release conditions revoked. Courts really do not like that. They do not like any idea of witness tampering. Another point that hasn't really been brought up from the court that I've heard, or anyone else really, is if you think that you're going to be indicted any minute now and you're coming to New York in anticipation of indictment because you're so cooperative, why do you have pink drugs, ecstasy, 2C, whatever it is, on physically on your person, and firearms with obliterated serial numbers in your home. Why would you have that if you really thought that you were going to be arrested? So I think that all goes against that argument for the defense. I think it was more that he was just narcissistic and didn't think that anything would ever come to him, and he would just get to go on doing whatever he wanted.
Yeah, see that's the problem, and I mentioned that before in the government's letter. Is this idea it didn't stop, right? These allegations, yes, they're from a number of years span, but if he has recently been contacting witnesses, if he's in New York and he has narcotics on him, which again the allegations were is that he was supplying people with narcotics during these freak-off sessions, and then I mentioned this letter from the prosecution that it says, since at least in or about January of 2024. Which, by the way, he probably thought he was under investigation. The raids didn't happen yet, but the lawsuits happened. When the defendant was unquestionably aware of the criminal investigation, the evidence shows that he engaged in multiple freak-offs, some involving the interstate transportation of individuals to participate, has continued to use narcotics, and has contacted multiple witnesses. So, look, the Neama, they're saying will take away his ability to do any kind of criminal activity, but it's not like he's sitting alone in an isolated apartment. He has this team. And I think what the prosecution has been saying, even if he personally doesn't have access to firearms or a phone, he can somehow get that message out, right?
No question, Jesse. He is running a criminal enterprise, and that's something that the government keeps harping on in their detention memo. And Natalie raised an important point. Let's say, in theory, Diddy were granted pretrial release. He would be subject to the standard conditions: obey all laws, no contact with witnesses. And there's a pretty high-profile case where an individual was granted bond, he contacted witnesses, and that bond was revoked. And that was Sam Bankman-Fried in the FTX fraud case. So if Diddy had contact with witnesses while he was out, federal judges routinely revoke bond and remand people into custody if that happens, because that's considered tampering, obstruction of justice. Really goes to the heart of our criminal justice system and affects the integrity. So that's a definite no-no. If you're under indictment, you're under investigation, even if you're going to be sued civilly, every lawyer will tell you, don't destroy evidence, don't contact witnesses. And we know that Diddy had lawyered up and did this anyway, at least allegedly.
So I'm being fully transparent with everybody who's watching this. I didn't ask you that question because of the update that we just got, but it's almost like the court is listening to this live feed, because the judge just asked, under your plan, would he have employees? Right? Would he have employees? And the defense says they handle his finances. They're in California. Would he be able to leave his residence? The judge asked, no. The judge also asked, in the security, they could be there in the house? The defense, yes, in shifts. We could put cameras filming 24 hours a day. So at least the judge maybe seems receptive to it, or at least asking questions. Natalie, what do you think?
Judge is giving him the full opportunity to be heard and to make his record, right? But I think that this is a case of it just would not look good. This is not something that's available to anyone else. And I can't see a reason for why someone should be able to use their wealth to turn their home into a prison. And then we would have to trust that the company hired by the defense, paid for by the defense, would then follow through and not be at all influenced by Diddy and their supervision of him within his home. I can't see it. It seems massively unfair to indigent people who could never afford to do that.
So here is a great question that we just got from one of our followers on YouTube. Excellent question. It's from All Hail. The question, Neama, is how did Diddy know who were the witnesses for a sealed grand jury indictment? How was he given the list of the witnesses trying to get him indicted? I think you can even extend that. If he's reaching out to people in general, couldn't you say that in and of itself is evidence he knows what he did, right? Oh my gosh, they're charging me with what are they even looking into? I'm under investigation? What did I do? But the fact that he's allegedly reaching out to people means he knows exactly what he did. So how would he know who the government's speaking to?
Well, it's evidence of his guilt. He knows who was present at these freak-offs, right? He knows who the witnesses were. And let's be clear, grand jury proceedings are supposed to be secret, but these are some of the worst kept secrets out there. You have reporters who sit outside the U.S. Attorney's office. They see who's coming in and out. We knew witnesses were testifying before the grand jury because, Jesse, you and I, Natalie, we all do a lot of TV. And reporters are very good at their job, and they got this information. So, yes, great question. But to answer in two ways, because of great reporting and because Diddy knows who is going to be a witness against him, that's why he was able to contact them.
I have a question for either of you. I think it's if whoever wants to jump in. So for a racketeering case, right, where you have this criminal enterprise and you have all these underlying predicate crimes that he's not actually specifically charged with, like kidnapping or arson or forced labor, does the prosecution nonetheless have to prove that beyond a reasonable doubt? Do they have to prove forced labor beyond a reasonable doubt? Do they have to prove kidnapping beyond a reasonable doubt? And some of these are state charges. Or is it preponderance of the evidence? I mean, I guess I'm trying to understand what a prosecution of a racketeering case like this would be. Is it just you have to establish that there's an enterprise, there's a criminal enterprise, there's a pattern, there was a common scheme? How much of those underlying crimes does the jury have to believe? Who wants to take it? Anybody want to take it?
I can take it as a former prosecutor. You have to prove every element of the crime beyond a reasonable doubt. And in a RICO conspiracy case, obviously you have to prove the unlawful agreement. You have to prove the overt acts and furtherance of the conspiracy. Obviously, we know the enterprise. It doesn't have to be a formal organization. It's defined as a loose association of two or more people. And like you said, Jesse, you have to prove those.
Okay, Neama, I apologize. We lost your audio right there. Natalie, you want to pick it back up?
Neema's actually absolutely right. You have to prove every single element of every single offense beyond a reasonable doubt. And if the element of the offense is that he kidnapped someone or committed arson by blowing up Kid Cudi's car, for example, they would have to prove beyond a reasonable doubt that he actually did those things. And it has to be at least two of those acts within the span of 10 years in order for it to be predicate offenses for RICO. So, Kid Cudi has already come out and said, yes, his car was blown up by Diddy. So I think they'll be able to at least prove that. And we know Cassie has come out and said that yes, he did sex traffic her. That's what she said he did to her, sex traffic her. And so those two events happening within 10 years of each other inside the statute of limitations, that's how the government would be able to prove their case.
Okay, that's important to know because we're trying to understand not only what the charges are, but also what the defenses would be. I have another update for you. Oh my gosh, I wish we had cameras in there because apparently it's getting a little heated. The judge is referencing the infamous 2016 hotel video that we mentioned before where Combs is allegedly beating Cassandra Ventura. The video is troubling. He was 40-something years old. The defense, he realized he has a problem with drug addiction and anger. He went into a rehab program for a period of time. They loved each other. The sex and the violence were totally separate, motivated by separate things. They were close to being intimate. They would bring a third person on. They chose that. Then the judge is talking about what does that have to do with him punching her, throwing a vase at her? What's love got to do with that? The defense, that was jealousy from infidelity in both directions. Mr. Combs and this other person, the violence is from that. Judge says, what is your point? Neama, if you're back with us, what do you make of it? All right, I think we're working on Neama. Natalie, I'll go to you.
Jesse, let me jump in here. First of all, I audibly gasped when the judge says, what does love have to do with that? Because when I was reading through there was like a Twitter thread that was about the hearing yesterday, and the defense counsel, I thought this is where the defense counsel made their biggest mistake in the hearing yesterday, and I cannot believe that they repeated it again, which was by victim blaming. Completely unnecessary here when talking about the two factors of dangerousness and flight risk. When it comes to dangerousness, if you want to pull Diddy away from what he did in front of that elevator in that hotel room, you say that that was a long time ago. He's worked on himself. He's no longer dangerous. He would never do something like that again, right? Like, you cannot hold him in jail because of something he did 8 years ago, let's say. But instead, he's saying, she was into this. She liked this. And she attacked him first. Nothing on that video justifies anything that the attorney is saying. That was a brutal assault, visceral to watch. And so I think that that was a landmine that the defense attorney has stepped on twice. So I'm not going to be surprised if Diddy is held again now, because he made the cardinal mistake 2 times. And that's really what the dangerousness assessment is all about. You can't assure me that your client is not going to harm somebody again in the future if the best explanation that you can give is that she was asking for it. That's terrible.
Why do you think he admitted it was him? Why do you think he went on that Instagram and admitted it was him, Natalie?
Admitted it was him that what? Sorry.
Well, I mean, so on in that Instagram, right? He didn't have to respond to that video, but that video was so clear. He had nothing really to say, but he says, "I'm sorry, I was messed up." You think his lawyers advised him to do that?
No, I don't think his lawyers advised him to do that. I think that I never thought that Diddy was taking the potential of a criminal case seriously, even though he retained counsel to, look into it and everything like that. I don't think he ever thought that this day was really going to come, because I said it at the time, this statement is incriminating. Yes, we can see that it's him clear as day, but don't admit it, because now when you're in court trying to get out, you can't say, we don't know what was going on that day. We don't know when that video was from. I don't know anything about that. That wasn't my client. I don't know what they're talking about. Right? You have taken away all the authentication issues that could possibly arise.
Oh boy, yeah, I don't know if he's looking back on it and thinking that was the best decision. But I'll tell you what, Natalie Burrell, Neama Rahmani, I want to thank you both for coming on. Neama, sorry we had a couple of audio issues. We are going to have to sign off right now. We'll wait to see what the judge decides, whether or not Sean Combs will be locked up pending trial. We'll wait and see. Thanks so much for joining us, everybody. I'm Jesse Weber. Catch you next time.